thank everyone for joining us here tonight as we talk about the estate planning basics. My name is Scott Fisher. I'm one of the financial consultants here on our team with John Graham and Associates. Presenting here tonight, we have Chris Franklin, another one of our team members and financial consultants on our team there with John Graham and Associates. So, yeah, thank you for everyone for joining here tonight, and just want to remind everyone that here we're doing these educational events every single month on a variety of topics. So if you know of someone that could benefit from listening to the estate planning basics or any of our future topics there that we're going to be speaking about, make sure to invite them and join yourself as well. So without further ado, I'll let Chris take over here and talk to us about the estate planning. Chris?
Again, thank you everybody for joining us tonight. We're going to be talking about estate planning basics and what the estate planning process is. So what is an estate plan? An estate plan is a map that reflects the way you want your personal and financial affairs to be handled in case of your incapacity or death. Who needs an estate plan? Chances are you do. It's not just for the wealthy. Without an estate plan, you can't control what happens with your property. If you die or become incapacitated, an estate plan makes your wishes clear and helps avoid family disputes. And proper estate planning can preserve assets and provide for loved ones. You may especially need it if your spouse isn't comfortable with financial matters, you have minor children, your net worth exceeds the federal tax exclusion amount, which is $11,700,000 in 2021, or if less, your state's exemption amount. You own property in more than one state, financial privacy is a concern to you, or you own a business. So some basic estate planning concepts are planning for incapacity, healthcare, property management, planning for death, wills and probate, tax basics, lifetime giving, life insurance, and trusts. So when we talk for planning for incapacity, it's a big subject because incapacity could happen at any time to anyone. For example, the day after my high school graduation, one of my best friends was broadsided by a Suburban in his tiny compact car and has lived with a very significant incapacity for the remainder of his life. And failing to plan for this means that a court would have to appoint a guardian. Lack of planning increases the burden on your guardian. And your guardian's decisions, most importantly, may not be the decisions that you would have made for you. Some things that we need to take keep in mind when we're talking about this is healthcare directives. The three big ones are a living will, power of attorney for healthcare, and a do not resuscitate order. A living will puts your instructions in writing so as not to be confused about what you may or may not have wanted. A durable power of attorney lets you designate who will make decisions on your behalf should you not be able to. So can cut out some of the family squabbles. And a do not resuscitate order directs that resuscitative measures will be withheld or withdrawn if they are necessary. Other things that we want to look for when planning for incapacity are property management tools. Three big tools for property management in your incapacity are joint ownership, durable a power of attorney for property, and living trusts. Joint ownership allows the joint owner to have the same access to property as you do. A durable power of attorney lets you designate, again, who will make decisions on your behalf, but this time for your property. And a living trust lets a successor trustee take over management of the property should you not be able to. So what happens if you die without an estate plan? Some property passes automatically to joint owners or designated beneficiaries such as IRAs, retirement plans, life insurance, or trusts. All other property is generally passed on according to state intestacy laws. Intestacy laws vary from state to state. They typically pattern a distribution that divides property between the surviving spouse, if there is one, and any surviving children. Your actual wishes are irrelevant because it's all determined by the state and not by what you would want, and it can cause many potential problems. This graph here actually is fashioned after Illinois intestacy laws. If you were to pass today, the state would determine without an estate plan that half of the estate would go to the surviving spouse, while the other half of the estate would be divided amongst your surviving children in equal amounts, regardless of whether that's what you wanted or not. So it's important to have a plan. If you have a will, your will will go through probate. A will is the cornerstone of any estate plan, and it directs how your property will be distributed. It names an executor and guardian if you have any minor children. It can accomplish other estate planning goals, such as minimizing taxes, and it's written, signed by you, and witnessed. How the probate process works is most wills will go through probate. They're filed with the probate court. The executor of your estate collects assets, pays your debts, files any tax returns necessary, and distributes the property to heirs. And typically, the process takes several months to a year. With probate, like anything else in life, it has its pros and its cons. Some pros are typically the time and costs are modest. It's court supervised. It does have protection against creditors. Some cons to probate are it can be time consuming if you have a complex estate. Transfers of titles can be delayed. There are fees that are associated with it. Could have ancillary probate, and it becomes a matter of public record. So can you avoid probate with a proper estate plan that's designed to control what assets pass through probate, or to avoid probate? You can. You can own property jointly with rights of survivorship so that if you were to pass, it would pass on to the joint owner. You want to make sure that you complete your beneficiary designation forms for properties such as IRAs, any retirement plans, life insurance, and the like. You can use trusts. You can make lifetime gifts. Another thing you could do with estate planning is affect your taxes. Transfer taxes include things like the federal gift tax, which is imposed on transfers made during your life, the federal estate tax, which is imposed on transfers made upon your death, and the federal generational gift transfer tax, or skipping tax, which is imposed on transfers of individuals who are more than one generation below you. So typically this is going to be grandchildren. And this applies both during and upon your death. So the federal gift tax works, again, during your lifetime. And certain gifts are excluded, such as you can gift $15,000 annually to anyone, and it's excluded from this amount. You have a total of $11,700,000 excluded from all transfers, both gifts and estate, combined for 2021. And it's the largest federal gift and estate tax exclusion in US history. How the estate tax works is upon your death, any gifts made by your estate to a beneficiary apply. It does not apply to transfers typically made to spouses or to a charity. The $11,700,000 excluded does apply here for 2021. And any portion of the exclusion used for gifts will be unavailable to the estate. So when we look at the federal estate tax, there's a new feature that's important for married couples. It's portable, meaning that any unused portion left by a deceased spouse can be transferred to a surviving spouse. So that means that a total of $23,400,000 can be left to beneficiaries tax-free in 2021. The generation skipping transfer tax may apply to transfers to someone more than one generation below you, such as a grandchild. Again, the $11,700,000 tax exemption is still there for 2021. But unlike the gift and estate tax, the GST tax is not portable. So any portion of that $11,700,000 that isn't used by a deceased spouse does not transfer to the surviving spouse. When we look at the totals from years past, you can see that from 2019 to 2021, both the gift and estate tax exclusion amount was raised from $11,400,000 to $11,700,000. So was the generation skipping transfer tax. Say that one 3 times fast. Another option we can look at is lifetime giving. This lets you see the recipient enjoy your gift. So it's gifts made during your lifetime. It lets you minimize transfer taxes by taking advantage of that $15,000 annual gift tax exclusion and other tax deductions. It removes future appreciation of property on your taxable estate. And there's no step up in basis like when you pass over after death. Your current basis in the property carries over instead. So some transfers that are excluded from the gift tax. You can give, again, $15,000 to as many individuals as you want, federal gift tax free, $30,000 if you and your spouse make gifts together. If you're contributing to a 529 college plan, you can contribute up to $75,000 or $150,000 with your spouse, gift free or gift tax free. And there's no gift tax on amounts paid directly to school for an individual's tuition, nor is there gift tax on amounts paid directly to a medical care provider for an individual's medical care. Another tool we use in estate planning is trusts. They're a very versatile tool in that they can protect against incapacity, help you avoid probate, and minimize taxes altogether. They allow for professional management of assets, provide safeguards for minor children, elderly parents, and other beneficiaries, and can protect assets from future creditors, as well as allow you to maintain control over the property inside the trust. So what is a trust? A trust is a legal entity that holds your property. There are parties to a trust. There's the grantor, which gives the property to the trust. There's the trustee, which manages the trust property according to the terms of the trust agreement. And then there's the beneficiary, who receives the rights to the trust property according to the terms of the trust agreement. There are living trusts and testamentary trusts. So a living trust is a trust that is created by the grantor during their lifetime. And a testamentary trust is a trust that is created by your estate upon your death. In revocable and irrevocable trusts, A revocable trust is a trust that can be changed at any time, and an irrevocable trust is a trust that once it's created cannot be changed without the consent of the beneficiaries of the trust. Another thing to think about with estate planning is life insurance. Life insurance can provide an instant estate for you. It can provide needed estate liquidity to pay debts or end-of-life medical care. The proceeds are included in your estate for federal estate tax purposes, unless your estate plan addresses this issue. And the key to this issue is the ownership of the policy. In order to take advantage of that, you can do an irrevocable life insurance trust. So you would create the trust and name a trustee and beneficiaries. The trust would then purchase life insurance on your life that is owned by the trust. You would make regular cash gifts to the trust, which they would then in turn use to pay the premiums on the policy. And the beneficiaries can still technically withdraw cash gifts during a limited window of time. Upon your death, the trust would receive the proceeds of the policy. The proceeds are not subject to estate tax, and the proceeds are distributed according to the terms of the trust to the beneficiaries. They receive the full proceeds free from estate taxes. So in conclusion, have you implemented a plan for your incapacity? Do you have a valid will? Are transfer taxes and planning a concern for you? And do you have an overall estate plan that reflects your current wishes and circumstances? If not, or if you know someone who would like a review of a plan they currently have or to create their own plan, please see Scott or myself or any of us at the John Graham and Associates team. We would love to help you plan your estate. Thank you very much for attending tonight's seminar. Any questions at this time?
Biggest things with an estate plan is, making it as easy as possible for loved ones. And going whenever this comes into play is exactly when you're perhaps not around, and when it is already a emotional time for your loved ones, that you want to make it ideally as simple as possible for your loved ones to handle your estate. And so, but between that and then knowing with trust, knowing that irrevocable versus revocable, I think, in my opinion, is one of the biggest things of, if you do want to make changes in the future, because things happen, you want to make changes, you want to make sure it's revocable so you can do so. A question here of, who should you pick as a trustee? So that's a great question. And truly, you have a couple of different options. One of the popular that we've seen with people would be a family member, either somebody, one of your kids that you have a high trust in, but also what's a popular option is what's called a kind of a corporate trustee, where you are able to hire a bank and their trust department to be the trustee of your trust. There are benefits of that where, hey, if you don't have a high trust level with a family member or one of your children, where you can hire through a bank, through their trust department, a trustee to be an unbiased opinion, and go directly according to what the trust states. So you have a couple of different options of either family members or now the bank trust department will be the trustee, and sometimes that can come with a small fee. So there might be a cost to that, but also the cost might be worth the benefit.
Especially if you don't have anybody you trust to, like, really trust to handle your affairs. That is an excellent explanation there, Scott. Debbie asks, how often should you review your trust and will? I typically recommend every 3 to 5 years to take a look at it, review it to make sure that it reflects your current circumstances and current wishes. Thank you for asking that, by the way. Our oldest daughter turns 7 and our youngest turns 5 this year, and my wife and I need to look at our will. So
another question is how do you feel about will making software like Willmaker? Yeah, and you know what, we do get this question quite often of, well, hey, do I really need a lawyer? I know I can just kind of do it online, or I found a website, or kind of one of those scenarios. In our opinion, we would very much recommend working with an estate lawyer and not doing the online softwares, simply because every state has different laws. If you own property in multiple states, it makes it more complex. And it's something where having the ability to work with an individual and someone that you can sit across the table with and feel comfortable that you're getting that right advice, we think that's very important, in that it creates less room for error than working with something online that it might or might not be trustworthy advice, and that we would just lean more on the cautious side of working with a licensed estate lawyer. And that's perhaps a little bit specific as well, is there's a lot of types of law, and where if you'd want to work with an estate lawyer that deals with estate planning, that knows the rules and regulations, and maybe not just somebody that does criminal law that really doesn't know anything about estate law as detailed. So that's another tip for that.
Some typical reasons for trusts are if you have a very complex estate, again, properties in multiple states, if you want to avoid certain assets going through probate, if you'd like to keep your estate private and out of public record. Those are typical reasons for why you would want to trust. Also to help you with the estate tax issues that arise.
Yeah, and I would add on to even that, Chris, of the trust is just so customizable, where we've seen with other clients there of farmland is pretty large here in central Illinois, of you can put things in your trust of stating your kids and grandkids cannot sell the land. And so putting a little bit more of those rules you can put into the trust that you might not be able to add into a will, of what you would like to see with your assets after you pass.
I think the best way to say that would be it allows you to maintain a higher level of control over your assets.
Absolutely.
I did bring up one excellent point I would like to say, though. He said the words put into the trust. It's great to have a trust, but unless you work with an estate attorney to make sure that all of your assets are put into the trust is only as good as the assets that are inside of it. I did meet with a client once who had a trust and had never put a single thing into it. So there were lots of questions.
We have another question here regarding, hey, if we left money to grandchildren for education purposes, does that need to go through a trust? little bit of a complex answer here, but no, it doesn't. There's a lot of different options for leaving the inheritance and education specifically, where a trust would be one option. There's a couple other ones there as well where we would, recommend sitting down with your financial advisor there to see what makes sense, if it makes more sense to do lifetime giving, as we spoke about, of giving while you're still alive, or if one of those other avenues would make more sense. Hey, yeah, we had a lot of great questions here, and I think that's, the of talking about estate planning is, I've definitely felt that it's probably one of the most under talked about, or not the least talked about topics about financial planning, because a lot of people don't want to think about it. And even though that's common, it's still something that you want to make sure that you have a plan in place, that you're reviewing it regularly, just as you do your investments, and making sure that your I's are dotted, your T's are crossed, and everything's where you want it to be. So with that, we'll kind of wrap up here our conversation for tonight. If you enjoyed learning about those estate planning basics and really what everything comes into it, we'd love to see you come back here on either on Thursday here later this week. We're having our same conversation here. If you think there's somebody that could benefit from listening to the presentation and can have a lot of takeaways, we invite you to invite them as well here. So with that there, Chris, everyone have a great night, and we'll see you guys soon.
Thank you for joining us this evening.